I think we've gone above and beyond just from what I have witnessed in the past couple of days. I've been extremely inspired by the young people who have participated. This year, we've had almost 15 law schools participate in the Moot Court, which is a little bit more than last year. So just to see the interest, the amount of time, the arguments, that have been put forward, but also the response by the bench to the arguments as well has been extremely inspiring and has gone above our expectation for the event.
It's not in contention that customary law is a source of law in Kenya. What is in contention is, where do we find the balance? Where do we strike the balance?
As a pointer, I think the paper itself and the content was excellent, but just it would be a pointer on just the presentation in itself, in a manner that you keep the audience engaged and interested in listening to the topic.
I've been a fan of Moot Courts since way before LLB. So the first thing that I wanted to do when I get to law school was participate in moots. And I really tried to get into mooting, my 1.1. It was difficult because, it's technical, it's hard.
Mooting is I want to call it playing ground, or the furnace in which you create good trial attorneys. And if we're trying to create good trial attorneys that will be defenders of the environment and of communities, then we need to hone those skills at this particular level.
With that, the respondents ask this court on these grounds to dismiss the claims that have been made and put forward by the petitioners.
My first question would be, at paragraph 27, it is clear that local leaders led by Mzee Juma organized the pastoralist resistant march, and over 1,000 people turned up. You're citing excuses relating to linguistic barrier and their pastoralist nature. How did Mzee Juma manage to get 1,000 people for a protest while you couldn't?
When we started a year ago, even when this conversation was starting about 2 years ago, maybe more, there wasn't a lot of interest from the student body, because environmental law and conservation law had been relegated, right? But right now, as you can see, the auditorium is full. We have over 150 participants and people who've given their time to be part of the mood. So from a general perspective, this is definitely the right trajectory, and hopefully it will grow into something bigger. It will be the East African moot as opposed to the Kenyan moot.
Honorable Justices, the first issue is a contextual question of whether the rights of the Ramila community, the right to self-determination, free, prior and informed consent, and public participation was upheld.
The Moot Court sessions were very, very educative and very informative, because during the sessions we were not only submitting, but the judges were asking us questions about current issues affecting, the indigenous communities, for example, the Ogie community. And this has actually helped me in that I am able to familiarize myself with what is happening to the indigenous people in Kenya, and seeing the response of the government, seeing the response of the people regarding what's happening to the Ogie community. And apart from that, I am very passionate about litigation, and I see myself arguing before judges on behalf of my clients. And on that same breath, the judges will give us very gracious comments and very good comments that I believe are going to help me and are going to be very beneficial to me when it comes to me advocating for my clients in court.
The presentations were good, and congratulations to everyone for taking part in this competition. To the final teams, whenever you get a moot question, always try to do deep research over and beyond the issues raised. And then secondly, on the presentation style, try and work on your presentation style. Be conversational.
It's important to listen to the judge. The moment you are asked a question, that becomes the most important part of your submission, not whatever it is that you intend to submit. And secondly, pace yourself. You ought to pace yourself so that we are able to hear you, understand you, and so that we are also able to engage you.
We've seen a really tremendous improvement in two very distinct ways. Number one, the quality of submissions by the students has really gone up. Maybe three. Quality of submissions by the students. Interest. This time we had about 15 different law schools actually have become part of the competition, the Moot Court. And I think the other distinct one is the fact that we've actually gotten a lot of interest from practicing advocates to serve as judges and mentors within the Moot Court competition.
We want to provide as much opportunity and reach as many law students as we can, and so looking at how we can diversify that and make sure that we also bring even more law students and law schools to be part of the moot. The importance for us is how much we can educate and inspire to take action at this time when climate justice needs to be a priority for so many. So the more advocates we have, the better for us. The more we can promote indigenous voices, which is at the core of what we do at Natural Justice. Environmental law and climate justice are not the easiest topics. Also, as a lawyer, I can admit to that. And so engagements like this provide opportunity and for students to think differently, to learn as they are part of the process as well, and hopefully take this up as a long-term investment in themselves and their career.
A lot of lawyers become lawyers because they don't want to deal with the sciencey stuff. But when you're a practicing environmental lawyer, you have to understand the science of climate change. You have to understand the science of forestry. You have to understand the science of a lot of the other underlying sectoral sectors, ideally. And so my number one advice would be, don't be lazy. Don't just read the law stuff. Widen your reading and widen your curiosity, and that is going to translate into a very, very fantastic career in environmental law.
You have really submitted your arguments, well thought out arguments, demonstrating your breadth of knowledge of not just the facts of your case, but also your knowledge of the law. So I congratulate all of you for that. I would just urge you to note that your case is not won on the day of making your submissions. Your case is won, at least 80% of it, by the preparation that you make and your knowledge of the law at the international, regional, and national level.
I am passionate about children's rights, but over the years, I have developed a keen interest when it comes to environmental law matters, and I am pleased and honored to have been selected to come and represent the university in this particular Moot Court.
The malicious character of the current county government, we seek that the court directs that these monies be directed to the CBOs. It is our prayer.
The CBOs that you complain, they participated in public participation. It's okay. Thank you. Thank you.
It has been very inspirational. I think the amount of work that has gone into preparing for the Moot Court, just from the students themselves, but also just from Riara and everyone who has been involved, Natural Justice as well, has been incredible to see. I've appreciated as well that we've had live coverage, so those who have not been able to join here physically could engage as well online. And I think for me that is also important to see how much we can expand the opportunity to others to be engaged. The arguments have been exceptional. I think there are parts that they have spoken better than myself or anyone at Natural Justice could have. And so for me that has been incredible to hear.
One thing I'm interested to know was a community development agreement concluded as a basis of the carbon offset credits, 6.8 million carbon offset credits that you are flaunting to justify your actions.
And we understand the corpus of that question arising from Section 23 of the Climate Change Act, but we must consider that
was it concluded between the government and the community?
The agreement itself.
It's a simple question.
I've also reflected if I was ever this active in law school when I was in law school, and I don't remember being this active. So it's been very, very interesting and engaging, especially for the law fraternity, but I think anyone else. This is an opportunity to even inspire young people to be lawyers, to come into the law profession, and I really think that's the essence of the Moot. And I hope for especially those who have participated, they have felt the benefit to themselves. They have seen that this is a credible purpose for them, and in the long run, just as I said, the understanding of how important and imperative climate justice is, for me, is the underlying reason for the Moot and for this experience.
I'll keep on encouraging you. Don't shy away. For those who turned up and took the challenge, keep participating in more opportunities and challenges. And of course, you'll continue to learn more and interact more on that.
I'm very, very much grateful to Natural Justice in partnership with Vera University for conducting and organizing this particular Moot Court, because I now know how best to articulate my issues. I now know how best to address the judges. I now know how best to respond to questions that are posed to me regarding my client's case.
Thank you so much, Natural Justice, for making this happen. Thank you for the donors who came around. Thank you for all the partners. Thank you to Riara for accepting to host us, and welcoming, sending the invitations without discrimination at all. I feel overwhelmed by the many things that I want to pass. I don't think there will be enough.
I think this is one of the best partnerships that this school has, and we're really looking forward to a longer term engagement, specifically with Natural Justice and our new partners, the Center for Moots Africa.
The opportunities are endless. I think investing in themselves and finding a purpose, the power of law is one that is completely undefined, and it's for them to define themselves. I did start very much like them in a law school, and almost I think it's 20 years now. This is where I found my purpose in advocating and defending for people's rights. And so the power of the law is what we stand for, and it's what I want them to realize, that their capability in using that law can really change and shape the now and the future.